Okay. We have several uh, topics here with respect to the 16 measures before us for deliberation. First is, one is annulment. Second is legal separation. Third pertains to legitimate or illegitimate children. Fourth is the property regime. Fifth is the foreign decree of dissolution of marriage. Six is the authority to solemnize marriage. Seven is about solemnization of marriage. And eight, psychological incapacity. Let's discuss first annulment. Okay. Honorable sponsor, Honorable Barbers, uh, has this House Bill 505 he proposes additional ground for annulment of marriage, which will read as 45-A. A marriage may also be annulled if the parties have been separated in fact for at least 5 years. Okay. May we hear from our resource persons? Any comments from the body or from our resource persons?
Good morning, Congresswoman, Attorney Legarda.
Oh, our idol.
No, we met before. So may I comment? May I comment on each bill in seriatim, as we say in the law?
Opo, please proceed po.
Thank you. On HB 502, separation in fact for 5 years, may I propose that in fact and allow the marriage to be annulled, no? Annulled. That's addition to Article 45. Article 45 talks about concealment or insanity. Concealment, there's either fraud or concealment or lack of consent. That's the purpose, that's the concept of avoidable marriage. So adding a separation in fact for 5 years, perhaps it might have to include a proposal that without giving any information whatsoever as to where that spouse may be, instead of just separation in fact, so that it follows the trend of fraud, concealment, insanity, or lack of consent. On HB 1143, which expands the grounds for legal separation, instead of adding a separate provision under Article 55, perhaps we might add violence of any nature under Article 45. Article 45(4) talks about force, intimidation, and undue influence. We can add continuous violence of any nature to include economic, psychological, and physical violence. And that way the marriage becomes voidable and the parties can in fact get it annulled. And the battered woman will be free without having to kill her husband. HB 1147, 2642, and 8478 are actually talking about more or less the same thing. Article 177 has already been amended by Republic Act 9858. A child born to a person below 18 years old can already be legitimated. Instead of amending Article 172, perhaps we could instead amend the second paragraph of Article 175, which unfortunately prejudices illegitimate children today, and allow natural children to seek filiation even after the death of his or her putative father. This was allowed under the new Civil Code, Article 285, under certain conditions: death during minority, in which case the child will have 4 years from attaining majority, and of course, add the post-mortem newly discovered recognition document. For reasons unknown to us, this was removed by the Family Code Committee when the Family Code came out. So we may want to bring that back. Article 286 allows impugning of recognition if prejudice, no? With respect to the amendment of Article 174, if we allow natural children to use the name of either mother or father without any other qualification, we will lose the very nice decision of the Supreme Court in Grande versus Antonio, which first recognizes the absolute and complete parental authority of the mother over a natural child. And the Supreme Court has said in a later case that the only blood known to run in the veins of a natural child is the blood of its mother. Okay? Under Antonio versus Grande, or Grande versus Antonio, with respect to 176, this allows the child, upon the child's attainment of majority, to decide whether to use his mother's name or his father's name. So it is irrelevant that the father has recognized him. There are many cases in our books where parents have tried to amend birth certificates because the putative fathers have been rapists, fraudsters, deadbeat dads. So we should allow the child to decide whether or not she wants to use her father's name. With respect to successional rights of natural children, I am informed that there will be a decision that will be coming out by the Supreme Court very soon, where the concept of Manresa's proven animosity will now become a quasi, and not quasi-conclusive. You need to prove animosity between the legitimate and illegitimate members of one family, so as to allow a natural child to inherit from her or his the legitimate child of the legitimate part of the family. I strongly caution allowing equal successional rights for marital and non-marital children, because this will encourage extramarital affairs and will put at naught the concept of marriage being the foundation of society. We might as well take out marriage if we're going to make all children equal. What we should do is punish the illegitimate parents. That's what I think we should do. With respect to Article 211, Article 211 is only for the parental authority of legitimate children. Again, allowing joint parental authority of the illegitimate parents over an illegitimate child will go against the Supreme Court decision, which acknowledges full and absolute parental authority of a mother over her natural child. And this is in accordance with the solo parents law, by the way. Okay. The equal protection is not violated by having a distinction between a marital and a non-marital child. And perhaps we can amend the law to instead of using legitimate and illegitimate, we can call them marital and non-marital children. And that way you take away immediately, that kind of prejudice against the so-called illegitimate child. With respect to 2262, the bill still talks about any other regime. And that is precisely our issue as professors and practitioners in Article 75 of the Family Code. Because if you look at the Code Committee discussions, there seems to be an implication that you cannot mix up regimes if you enter into a property settlement no prior to marriage. And it is repeated any other regime. So perhaps we should decide, what do you mean by property regime? Can we mix up the three regimes based on your property ownership prior to marriage? So say your SNC shares can be exclusive, your condominium here in Pasig can be conjugal, and any salary you obtain can be absolute community, for example, because it's not clear in the law. With respect to HB 5487, we agree that with the concept of amending Article 13, but that so that to allow the registration of a foreign divorce decree. But that means you will have to amend the civil registry law and Article 408 of the new Civil Code to include registration of the decree of foreign divorce. And you will also need to allow na Filipinos to obtain. Note that under the case of Republic versus Manalo, since we're talking about divorce, the Supreme Court now allows divorces obtained by Filipino spouses married to foreigners to obtain a foreign divorce decree, which divorce decree obtained by the Filipino can be recognized in this country by a court. So maybe it's time to just amend Article 26 to allow all parties who have obtained a valid foreign divorce decree abroad to remarry in the Philippines. That way, we don't have to worry about priests and the Catholic Church, because this will be in accord with Republic versus Manalo, a very recent Supreme Court decision. For HB 5511, the issue of parental consent or lack thereof is already addressed in Article 45. Parents of children between 18 and 21 who marry without parental consent can actually seek to have the marriage annulled. With respect to HB 7042, allowing virtual wedding ceremony, yes, this is a question I always ask my students in final exams. Would that be valid? And since Congressman Salo wants it to become valid, obviously it's void right now. So I agree. However, I think we should ensure, Congressman Salo, that we avoid weddings by proxy. Weddings by proxy.
Sir, that wedding by proxy is not part of the proposed measure, ma'am.
Yes, I know. I mean, what I'm trying to say is we should make sure that the people getting married are the people who are supposed to get married virtually. So I agree with that right now. And since you filed that bill, the answer is really no, it's a void marriage. There should be physical presence. Again, for 7500 House Bill, I strongly suggest, and I think Professor Balane agrees with me, he was a member of the Code Committee of the Family Code, that instead of calling them legitimate or illegitimate, let us call them marital or non-marital children, so that we address the idea of discrimination. For HB 8355, I don't understand the meaning of sexual hunger. Many of the definitions also fall under the concept of legal separation. And the the provision or one of the lines in HB 8355 that states, the offended party shall be without fault in any way, actually reverses the concept of Article 36 and jurisprudence thereon, the principle that even the psychologically incapacitated spouse may seek nullity of marriage. Okay? With respect to HB 8405, it is perhaps better to refuse to issue the license if an impediment is brought to the knowledge of the civil registrar, because no way will the civil registrar ever go to court. HB 8463 is already Republic Act 10572, May 2013, and HB 848, I forget to put in, is already Republic Act 10572, May 2013. The problem with the family code kasi is that when it came into effect, the majority age was still 21 years old. A few months later, the majority age was changed by Congress to 18 years old. So there are many provisions there which need to be removed, like Article 77, tanggalin mo na yan, because an 18-year-old can now enter into any contract he or she wishes. We also need to discuss the case of the Republic, the case of falsis versus civil register, where the Supreme Court more or less implied, although it was dismissed on grounds of technicality, that nothing in the Constitution prohibits same-sex marriage. We also need to discuss the concept of surrogacy. We already allow artificial insemination under our family code. Perhaps we should already allow surrogacy too, because that's how many children in this country of famous people that you and I know are having their children. And perhaps we should also, and I particularly refer to the Congresswomen representing Gabriela, we may want to already address the LGBTQI issues with respect to Articles 147 and 148. So I hope I have not taken up too much of your time and that my ideas and our proposals might have some, are useful, because actually I don't like legal separation, because the kids, the spouses will not be free ever. They're still considered, excuse me, married. So I like annulment and I like nullity. And of course, I like divorce. Thank you very much for allowing me this time.
Thank you so much, Attorney Legarda. That's very enlightening, coming from a legal luminary like you. We will take note of all your comments, and then we will probably deliberate more in details by our next meeting.
Forgot,
For
may I, excuse me, Chair, I forgot, by the way, for legal separation, while I was listening to attorney, to the representative of Gabiola, I'm sorry, your name escapes me, I'm very senior.
early process.
Yes,
Early,
sorry, Attorney Rep. Brosas. Legal separation is actually more difficult to prove in court than annulment or declaration of nullity, especially for the battered woman, because you need to go to a psychiatrist, because it says, or a psychologist, and you need to show two circuits of the cycle, no, of the violence, the cycle of violence. So it's really difficult to prove, because battered women really don't have much access to psychologists, which is why I like nullity, annulment, or divorce. Sorry, thank you.